Couldn't it go the opposite way, though, Judge, where they might say, all right, if you want us to attach an explanation to something we already did, we'll come up with one, but we won't reverse ourselves. We've made our decision. We're not going to do anything under the thumb or onus of you.
Yes, it could go that way, but it's unlikely to do so. I've reviewed the same record that Mr. Hammack reviewed, and the facts just are not there. There simply is no evidence that he's a menace to society. There's nothing in the record that they can point to justify that conclusion. There's nothing in the record that they can point to that he's going to flee, and even if he does flee, what do they care? Saves them money on supervision. Remember, he's already out of jail. He's living in a halfway house. In order to get there, there has to be some conclusion that he's not a menace to society. When you live in the halfway house, you live in there at night. You are free to do your work during the day. He leaves, he comes back. He leaves, he comes back. There simply is no evidence to support their conclusions. They'd be hard-pressed to come up with the same answer this time around.
By the way, what we're showing you here is when he was not in that halfway house or correction facility. This is when he was in the hard pen in upstate New York. Mr. Hammack, do you get a sense that this is going to be reversed then? When it's taken up, the parole board will be under pressure to just reverse itself? Because they could be under equal pressure to get very angry and say, don't tell us what we can do. We did it for a reason, and then come up with another reason, right?
Well, let me say a couple of things. One, there are many cases that I've seen over the years where we get a judge who makes a good decision in the case. In my opinion, it's a good decision. And he orders a new hearing, or she orders a new hearing. And in many of those cases, the guy goes back, and they just give him new reasons, and they still deny him. What the judge is saying, I think I have to agree with, if they were really trying to justify the decision that they made because they believe it to be the right one, they would have extraordinary difficulty identifying a factual basis to support the decision to deny release. But there's a new factor here. I just learned today. The Attorney General's office has filed a notice of appeal. And when the Attorney General files a notice of appeal, they get an automatic stay. So that order of Judge Huff to give Mr. Kozlowski a new hearing is on hold.
For how long?
Till the appeal is decided.
So he sits and stews in prison longer?
While he continues in work release.
Yeah.
I think just for the viewer's sake, the New York State Work Release Program is an excellent program. Corrections has been running it for years. Governors have limited the offenders who can go into it, basically to white-collar guys and drug offenders, but it really does put the guy back in the community. So that's number one of Mr. Kozlowski. Inconsistent with what the judge said, because there's been movement for Mr. Kozlowski in work release. He's home 5 nights a week. He's only in the facility 2 nights a week. So he really is back in the community with no adverse occurrence so far as the
hasn't done anything heinous. Hasn't done anything.
And then the other thing I'll mention to you, which the board referenced when they were interviewing him for release, they've been mandated by the New York State Legislature, effective in November 2011, to use risk assessment instruments in their parole release decisions. They did that in the case of Mr. Kozlowski, and although I've not seen his COMPAS report, that's what they call it, COMPAS, I've not seen it, guaranteed he's a minimal risk to reoffend. They don't have anything lower than minimal.
Judge, real quick, and I'm sorry to belabor this guy's in the control room, but to Mr. Hammack's point about now the Attorney General intervening to appeal here, how unusual is that to you?
Well, I don't think it's unusual here because this was a notorious case, and Mr. Kozlowski is someone that the state aggressively pursued, and as Mr. Hammack pointed out, was angry that he didn't accept their plea offer and forced them to go through an expensive trial.
But they got their pound of flesh. They got their pound of flesh. They get in prison long, much or whatever you call it now, much longer than would have been the case otherwise. So they got more than they wanted.
It's not enough of a pound of flesh for them. So they're going to take another shot at the appellate court. I didn't know about that. I'm sorry to hear that, but that's going to delay things. He's not going to be out in 2 weeks. The appellate court could take months before it even decides to accept the appeal, much less rule on it.
We're going to have the statement we had from Dennis Kozlowski's lawyer in a second, but do you find it surprising, Edward, that you would see out of nowhere the Attorney General's office intervening on what is essentially a parole commission matter?
I do find it, well, first of all, the Attorney General is the state's lawyer.
Understood.
So if Parole calls up and says, look, we don't like this decision from Judge Huff, we think you ought to appeal it. The process...
Is that how it would be done? They'd call him and then he'd say, well, I agree with you?
The Attorney General's office would not be involved until Parole notified them.
So that's the Parole Commission's way of saying, we stand by our decision, will you help us out?
That's right. What we would hope would happen, and it could happen in this case, although I tend to doubt it, but we would hope that the attorney from the Attorney General's office would get this, would review the record, and would reach the determination, what are we appealing? You know, why are we doing this? But I've seen cases where the Attorney General reacts reflexively. You know, they just go ahead and do the appeal and say, let the chips fall where they may. If the appellate division lets him go, bye-bye. If the appellate division holds him up, he'll get another shot whenever the parole board says he can come back and try again.
Which would be when?
In his case, his parole eligibility is in January, so he's going to see the board again in September.
Of this year?
Of this year, because they see the guys 4 months before they can be released.
Gotcha, gotcha. By the way, to that aforementioned statement from Dennis Kozlowski's attorney, and I quote here, Mr. Kozlowski and I are elated by the court's ruling because it validates what we said all along. After being a model president for many years, he has become a model participant in the work release program. We ask for basic fairness, nothing more. Judge, now this wild card from the Attorney General that could at best delay that. What do you make of that?
Well, I hope that the Attorney General will do. I say I hope, having reviewed the file. I don't even think he should have been prosecuted, much less incarcerated. Another argument for another time. But I hope that the lawyers for the Attorney General basically say to the parole board, we're not going to file this appeal. We don't think it's meritorious. We're not supposed to waste the court's time with frivolous appeals. If they do that, he'll be home free in a couple of weeks. If they don't do that, it's up to the appellate court how much time they want to take to decide to hear the appeal and then to rule on it, Neil.
All right, gentlemen.
But these types of appeals are not normal. They're not usual. This is out of the ordinary.
All right, and to Mr. Hammack's point, there is a disproportional interest in this particular prisoner and this particular case. Why, to this day, we have no idea.